So good afternoon, everyone. Can you hear me okay? Okay. So I'm so happy to be here to talk to you about some essential estate planning topics. I am a lawyer with Siskind here in downtown London. I've been there since I was involved with the bar in 2012. Way back when I started out doing estate litigation, so I've seen sort of what happens when things go off the rails. And now I do only planning and estate administration, so trying to prevent things from going off the rails. So this includes in my practice the preparation of wills, powers of attorney, and trusts, as well as advising estate trustees on the administration of estates. I also advise individuals on their obligations when they're acting under powers of attorney or if they're making decisions for someone else. And I do a bit of work also for individuals who are on Ontario Disability Support Units. So sometimes they will receive an inheritance that might mess up their receive benefits. So I help them structure that. And I'm also a certified trust and estate practitioner with the Society of Trust and Estate Practitioners. That's the TEP. Okay, so I'm going to try to also work with my slides here. Okay, so lawyers love disclaimers. So just to let you know, the information that I'm providing today is just for information purposes only. It can't be sort of individual legal advice. So if you do think you need some legal advice based on this, please reach out to us for that assistance. And then anytime I, make an opinionated statement, which might happen, those are my opinions. They're not, the opinion of my employer. Okay. So what I'm hoping to get through today, I'm going to talk for about an hour at a time to myself. So hopefully we end up in the right time, and then I think we'll have a bit of a Q&A. And if you're not comfortable, asking a question in front of everyone, I'm happy to stick around if you want to have a bit of a chat afterwards. So these are the topics I'm hoping to cover today. What is an estate plan? What is a will? What to consider when you're doing it, when to update it, what makes it legal or not, what powers of attorney are, and substitute decision making, and then some basics of estate taxation, because that's even been a hot topic a little bit. Trust and estate taxation has been a hot topic even in the mainstream news lately. Okay, so what is an estate plan? So broadly, it's really about anything that you do to prepare for the impact of your passing away or your incapacity. So it certainly includes all of the financial aspects of that, like preparing a will, preparing powers of attorney. It can also include, making sure any assets you have that have beneficiaries on them. So your beneficiary designations are up to date, like on life insurance, RSPs, TFSAs, RIFs, those kinds of things. So you want to make sure that that's kind of working together with the will that you've done. It can also include, anything more broadly. So things like, arranging and prepaying for funerals, kind of take that burden off of family, which is developed in final disposition, other associated expenses, like preparing for those expenses on death. And of course, advanced care planning. So thinking about, your own values and wishes when it comes to things like end of life care, moving from, an independent living situation into a more supportive living situation. The more information that you can think about and leave for family members who might have to deal with that, the better it is and the easier it's going to be for people to, respect what their wishes were, because they'll know what they are, and to carry out the plan. So today for me, I'm going to focus mainly on the legal aspects of an estate plan. So like the wills and the powers of attorney. Okay. So, preparing a will, what is it? Most people know that it's a document that sets out your wishes for the distribution of your estate on your death. In its simplest form, it's going to provide for who is in charge of administering your estate. So commonly we refer to that person now as the executor or the estate trustee. Those terms used to kind of mean different things, now we use them for interchangeably. And then it gives that person instructions for how your estate is going to be distributed. So depending on the family situation as well, maybe the will is going to be a little bit more complicated. Maybe if there's minor children involved, there's going to be some trust set up to hold funds for them, or other beneficiaries who maybe need that. So maybe they are somebody who is not so great with money, or there's another issue that you want the funds to be controlled for them. And then certainly, you know, when to update your will if you already have one. So really thinking about like what are the major life events that would cause you to make changes to that plan. So births, deaths, marriages, divorces, you know, a diagnosis that might impact you cognitively. It's a good time to review everything and make sure it's all up to date. I always tell my clients, pull out your copy every couple of years, take a look at it, and make sure it just still sits well with you. It doesn't mean that you have to come in and meet with me to go over it, but if anything changes, you know, you want to deal with that right away. It used to be the case that if you had done a will and then married after the date of that will, that would revoke the will that you had done. The law has changed, so that is no longer the case. So certainly the will may no longer be appropriate for a new partner situation. So it's a good time to take a look at that. As well, a separation or divorce, depending on the timing and the circumstances, may or may not have an impact on what you've done in your will. So also a really good time to take a look at that. More commonly, people usually will set something up when their kids are young to make sure that their kids are looked after, and then maybe 20 years or so go by, or maybe 30 or 40 years go by, and then they think, oh my gosh, my kid is like 40 years old with a job in Toronto, and maybe now I don't need like trust for them or anything like that. Okay, so I'm going to talk a little bit about what makes something a valid will. So has to be in writing, so no video wills. I know that's kind of popularized maybe in some media. I always think of there's a Siskind bit where she recorded a video will. It has to be written. And it has to be a final expression of someone's testamentary wishes. So it can't read as though it's a draft of something. It has to be pretty clear on its face that it's a will. Typically, if it's prepared by a lawyer, it's going to be signed in the presence of 2 witnesses, and that is the easiest way for a will to be valid. Ontario used to be what was known as a strict compliance jurisdiction. So that meant that either you had to have this will that was signed in the presence of 2 witnesses, or you could have what was called a holograph will, which is something that was fully handwritten by the person making the will, and then signed by them. Now we, you know, at that time, if the document didn't meet those requirements, it wasn't a will, like there's no even chance of getting it validated. Now we are what's called a substantial compliance jurisdiction. So if something kind of looks like maybe it's a will, you might be able to have a court say, yes, we think that that is the final expression of that person's wishes, and we're going to validate it as a will, even if it doesn't meet these sort of formal written requirements. So far we've seen that used for like a missed signature. So, you know, a lawyer in a signing meeting was chatting, not paying attention, and their signature was not on one of the wills that was on all the other documents. Pretty clearly was intended, but that could have been signed. That has been validated by the court. We've recently seen it used to obtain disclosure of a lawyer's file, which may have had a draft will in it, which is a little bit scary for estate planning lawyers that are filed. So we'll kind of see where that goes. But certainly, it's always best to avoid a court application if possible, because those are going to cost, to have a lawyer go and try to validate a will is probably going to cost, you know, several $1,000s to get that through the door. Okay. Okay, so the other thing to think about that I think is really one of the most important things that is often not given enough thought is who is going to actually be the estate trustee or the executor of the will. There's lots of factors to consider there, and you know, it's some people say, well, you know, I want all my kids to do it, and that's lovely, but it's going to cause potentially some difficulties with getting them all together, because they all have to act together, bring together. So they would all have to go to the bank, sign documents, meet with the lawyer, deal with all of the aspects of the estate administration. Sometimes clients say, well, my kids don't really get along, but I really think that once I'm gone, they're gonna pull together. And that's gonna be the thing that makes them kind of come back together, and it's really not. Sometimes people see the situation through rose-colored glasses. So thinking about, if you're gonna have more than one person, do those people really have the ability to work together and really setting them up for success in the estate administration? Other things to consider is like how motivated is that person, because it is a lot of work to do an estate administration. There's a lot of paperwork that you need to work through. There's a lot of dealing with, banking people, dealing with a lawyer, dealing with tax filings and that sort of thing. Is that person someone who can deal with all of that paperwork, move through all of that red tape, keep the estate moving forward, or are they more likely to be someone who's going to kind of stick their head in the sand and hope that it still gets done? Because we do see that from time to time. It doesn't need to be somebody with, a great deal of financial education, or they don't need to be like an accountant or anything like that, but just somebody who is going to have those skills to deal with the estate. As well as, geographic location is interesting. So now we can pretty much deal with an estate trustee in any jurisdiction, because so much now is virtual. So we can have virtual meetings with that person, we can have them sign documents and send them back to us. Most banks have branches all over the country, so they can go to different branches to deal with things. But really, if we have somebody who is non-resident in Canada, that can cause some problems. So in the case of an estate trustee who is not resident in the country, the court is going to want to know if that person needs to post a bond to secure the estate assets, because if they take all the assets of the estate and they go off to the US, very difficult for a Canadian court to get that money back. So a bond is an insurance product that basically secures the assets of the estate if the estate trustee removes them from the country. So that always needs to be addressed when there's a person who's not Canadian resident. If they are a US resident, that can cause some potential tax issues. It can actually cause the estate to be deemed to be non-resident in Canada, which means now they're going to be filing different tax forms, and tax forms usually in the US. And then potentially there could be some regulatory issues with the assets of the estate. So some financial institutions can't take instructions for someone who's not a resident. So those are kind of some things to consider. Also, on a practical level, like how well does that person get along with other beneficiaries of the estate? Are they going to be able to deal fairly with those people, keep them informed, and just try to keep things moving forward? Okay, so common issues that we kind of see in self-made wills, or will kit wills. So sometimes there's just errors or a lack of clarity in what the intentions were, particularly if there's sort of a failure to dispose of the entire estate. So sometimes what we see, particularly in handwritten self-made wills, someone will say, okay, well, I have a house, I have a bank account, I have a car, I've given away the house, the bank account, and the car, great, I'm done. And then they acquire something else that's not within that will, and there's nowhere for it to go. So it would follow basically the same pattern as if they did not have a will for that asset, which we'll talk about. Often we see incomplete trust provisions. So if you have a minor child and you say, okay, if my minor child receives a share of my estate, hold it in trust, and then that's all you say. If you say to age 25, actually, under the law, the child could claim that money when they turn 18. The trust is in full provisions that would make it a valid trust. And then the most common thing we see is just improper witnessing. So either, it's signed in the presence of one witness, or it's signed when there's no witnesses. One I just dealt with recently was where one of the beneficiaries and their spouse were the witnesses to the will of the deceased father. And what that does is the will is still valid, but the gift to the beneficiary fails unless the court finds there was no funny business happening in the execution of that will, so there was no undue influence that they were doing to sort of have more of the estate left to them without splitting. In our case, it was still divided equally among all the children. So it was, a court application that we needed to bring, but again, the actual cost to the estate of having to bring that court application was much greater than if dad had gone and just have a lawyer do a simple will. For them. Okay. So another thing to consider is that potentially not all of your assets are going to pass under the terms of your will. So if you have things that are jointly owned with someone else with a right of survivorship, or property that has a specific beneficiary designation, so like your RSPs, your REITs, your tax-free savings account, your life insurance, those are going to pass to those designated beneficiaries outside the terms of the will. Things that will pass under your will typically solely owned properties, assets just in your name, or property where it could have a beneficiary designation, but it doesn't. Silent, or it says that it's going to be estate. Issues that arise here are that sometimes people are not aware. So if you have a jointly owned asset with an adult child, the law presumes that it was intended to form part of the estate, not actually go to the adult child. So they're in a position of having to prove that they were entitled to that gift, which can cause some problems. The other thing that can cause some issues is, if your will has assets distributed one way, but the beneficiary designations don't match, then there can be a question of, what was intended. Did you actually intend to make an extra gift to beneficiary A, who was on the asset as well as in the will, or weren't you intending to have that asset? Was that done for just like convenience purposes, so that you didn't have to pay probate tax on the asset, which we'll talk about. So this can cause some issues if things aren't set up in a way that really works well together with the will. The other thing that we see a lot that people don't always realize is, especially with your RSP or your RIB, if you have a direct beneficiary on that asset, there is a tax issue that can come up. So when you pass away, you're deemed to dispose of all of your assets on your death. Your estate has to pay the taxes associated with that disposition. For your RSP, the financial institution has no obligation to withhold the tax, so they'll just pay it out to the beneficiary, and then the estate has potentially a huge tax bill because that amount is getting fully included in income year down. So if the beneficiary is somebody who is not a beneficiary under the will, now the beneficiaries are hit with that tax burden, and the beneficiary on the asset is just getting full amount. So sometimes you see those issues happen. The other one that's very common is the will has, a lovely trust in it, set up to hold assets for a minor child or a beneficiary with a disability, but then that person is named directly as a beneficiary on an asset as well. It's never coming into that trust. It's passing outside of the estate, which can cause some problems with the minor or a person who might now be trying to figure out how not to lose their disability benefits. So lots of things to think about in addition to just the terms of the will is what are the assets of the estate and how are they set up to actually pass on death. Okay. Okay, so I mentioned probate here. So this is a question I get a lot, like what even is this? And do I need to do it? So probate is the process of submitting the deceased's last will to the court and obtaining what is now called a certificate of appointment of estate trustee with a will. The rules of court don't actually say probate anymore. They say an application for a certificate of appointment of estate trustee with a will, which is why estate lawyers always still use the word probate because that's a bit of a mouthful. But essentially, it is submitting that application to the court, providing information about who the estate trustee is, who the beneficiaries are, what the assets of the estate are, and getting that certificate of appointment so that the estate trustee can prove to third parties that they are the correct person to be dealing with the assets of the estate. So the need for probate really depends on the assets involved in the estate. So typically, real estate requires probate, most solely owned bank accounts. The banks typically want probate so that they're comfortable dealing with the estate trustee. So whether or not an estate is probate, it doesn't depend on, you know, how well the will was drafted or that sort of thing. It's really what are the assets of the estate and what comfort do those third parties who are involved with the assets of the estate need to deal with the estate trustee. As part of that application, you're also going to be paying your estate administration tax or probate tax. So that is calculated as 1.5% of the date of death value of the assets over and above the first 50,000. So that's the calculation of the tax. It's actually a relatively small tax compared to all the other types of tax that you'll pay. But that's how it's calculated. That's what it is. It's a tax that goes to the provincial government. Once one asset needs to be probated, all of the other assets that are not passing outside of the estate need to be included in the probate account. So this is where sometimes we run into issues with bank accounts that are jointly owned with adult children. Because if, you know, say mom and dad have 3 kids, daughter A has become really involved in helping them deal with their affairs, they're not waiting to manage anymore, so for ease, they put daughter A on their bank account. And then on the death of both of them, daughter A says, well, the bank told me the money in that account is mine, because I'm on it. The law actually is, unless you can prove that they intended to gift for those funds, it's presumed that those funds are part of the estate, and you do have to pay probate tax on them if there are other assets that are part of the estate. So that's just something to keep in mind. We see sometimes people trying to do things to avoid the probate tax that end up getting pulled back in anyway, just because of the way it's done. As part of this application and the probate tax, after the certificate is received, the estate trustee also has to file what's called an estate information return to justify the amount of probate taxes that was paid. So that provides some more information about the assets of the estate and how the tax is calculated. There can be fines for filing a false return. So better to be honest and pay the 1.5% than try to exclude things and get audited and fraud on it. Okay. So this is about what happens if you don't have a will. So this is referred to as an intestacy. I was reading this from the Industry Institute report from 2023 that said about half of Canadians do not actually have a will. So this is always going to require a court application, you know, 99.9% of the time, unless there's really truly no assets in the estate, to get that certificate of appointment to name someone who can deal with the assets, because there's no will saying who should be the estate trustee. It's also always going to require the proposed estate trustee to address that security bond. So anytime there's no will naming an estate trustee, the person applying to the court needs to deal with the issue of the security bond. So making sure that the assets of the estate are secured, and that's that insurance product that I mentioned. So if the estate trustee does something bad with the assets of the estate, there's some insurance there that covers the beneficiary. The person who is able to apply is dealt with under some legislation. So typically, the first entitlement is with the spouse, or the legislation actually says the person with whom the deceased was residing in a conjugal relationship immediately prior to death. So not even necessarily a common law spouse under those various tests, but like really living with someone in a relationship, and yes, that person can apply to be appointed as the estate trustee. If there is no such person, then it's typically next of kin. So either adult children or other parents or siblings, somebody who can apply to administer the estate. So you can see sometimes how if there is no will, we can run into difficulties, particularly in more complex situations someone could have both a legally married spouse and a person with whom they were residing in a conjugal relationship immediately prior to death. And that's where things get really messy. As well, we get calls from time to time from funeral homes saying, like, who should I listen to about the disposition of the body? Because the wife is saying to cremate and the girlfriend is saying not to, and, it can get very complicated very. The other issue that arises, is the administration bonds, we talked about that. Okay, so then the estate also gets divided according to the legislative scheme. So this is where there are a lot of misconceptions about what happens when someone dies with a will. So many people think, okay, well, I'm legally married to my spouse, or I have a common law partner. Logically, that person is going to get everything that I have, so I don't need to worry about a will, or we don't need to deal with it until after one of us is born. So this could be the case, right? If all of the assets are jointly owned, your beneficiary designations are all set up to your spouse, maybe everything is going to work out okay. But if not, if there's assets that were solely owned by the deceased, that's where we're going to run into issues. So in the case of an intestacy where there is a legally married spouse and children, the first $350,000 of the estate is going to go to the spouse. So this is known as their preferential share. And then anything over and above that amount is going to get divided between the spouse and the children, depending on how many children there are. So if there's just one child, the half goes to the spouse, half goes to the child. If there's more than one child, a third goes to the spouse, and the remaining 2/3 gets divided up with the number of children. So this is true even if the children are minors. So we've seen situations where, for whatever reason, one partner owns the home. Sometimes people do that for asset protection or mortgage qualification purposes. If they pass away and their partner and their minor children are residing in the home, that can cause a lot of problems in terms of the children now having ownership interest in that asset potentially. That also causes the office of the children's lawyer to get involved. So they are a government body. Their job is to make sure that minors' interests in the estates are dealt with appropriately. So now you have someone else who's kind of overseeing what's going on with the estate, and it can get very tricky. So really just trying to keep people out of that situation is pretty important. And another thing to keep in mind is that those intestacy provisions only apply to legally married spouses. So the preferential share for a spouse does not apply to a common law spouse. Unless assets are jointly owned with that common law spouse, they are not entitled to anything from the estate of their deceased partner. They have to make a claim for dependent support or division of the assets to try and get something from the estate. So that can leave a common law spouse in a very tricky position, particularly depending on the dynamic with the leader of the family. And then if there's no closer children, then again we're looking at who are the closest living relatives of the deceased. So first it's going through surviving parents, that's where it goes. If not, then it's just siblings or siblings are dying to with nieces and nephews. Quickly, it can get to individuals with the deceased may have never wanted to benefit. You have an estranged brother in Alberta, and all of a sudden he's entitled to half the estate, even though you've never spoken in 20 years. And of course, this can get really dicey in situations where, there's a common law spouse, a legally married spouse, and minor children. So we can run into problems very quickly. There is some change now in the law for separated spouses not being entitled, but that depends on the legal situation of a bunch of different things. So that is complicated as well. So I guess my takeaway there is so leave it up to chance. Okay, so now I'm going to switch gears a bit and then talk about powers of attorney. So there's two basic types. There's your power of attorney for property and your power of attorney for personal care. Basically what this is doing is naming a substitute decision maker for you who can step in and make decisions. You become capable of making decisions for yourself. So the property is very broad, so it includes any property or asset related decision. It includes real estate, but also all your bank accounts, your investments, any other asset. The person can do anything that you could have done while capable, other than make a will for you or make changes to your will or change beneficiary designations, because while the state litigation lawyers would get a lot of work from that, it makes sense to like not let someone else change your testament wishes. The other type is, of course, the personal care, and that's covering sort of all types of personal care. So most people think of this as medical treatment related, which is true, but it also includes, you know, shelter decisions, hygiene decisions, food, clothing, basically any type of personal care decision you are able to make that for yourself. Okay. So in choosing an attorney, similar factors to think about as in choosing an executor. You know, a lot of people think that they should have someone who has some financial or business knowledge do the property thing, and then someone with healthcare knowledge do the personal care. And those are great qualities. If you have someone in your life like that, it is great. The most important considerations, I think, are, you know, making sure you're picking someone who's honest, has an ability to get along with, and potentially negotiate with other family members who may have opposing views as to what's going on. And if you're naming multiple people acting together, it's also really important to think about their ability to get along with one another and make decisions together. As well as if you're naming somebody to do personal care and somebody else to do property, there are decisions that might be made that impact on both types, right? So if you have to move into a different living situation, you have to look at both the personal care decisions associated with that, as well as how you can pay for it, right? So those people might have to work together. So it shouldn't be people who just absolutely cannot get along. Other things to consider is geographic location. So sometimes people want to pick someone who lives far away. It's possible to do that, but it is easier and more practical to have someone nearby, at least relatively local, particularly for personal care type decisions, because sometimes things happen very quickly, and someone needs to actually physically be somewhere to help you with something and make a decision or to deal with something. That can really make a difference. It's important to consider, you know, you change the name over time, so long as you're still faithful, you can remove the document and you can do one or name someone else. It's possible to restrict the powers of the attorney. So generally, the attorney, as I said, is going to be able to make any decision that you could make. But if there were concerns about certain things, you could potentially limit the types of decisions that you make, or make it limited to one asset or that sort of thing. You should definitely let the people that you name know that they are appointed. So you don't need their consent to name them. They don't have to sign anything. They don't have to come meet with a lawyer too. But there is no obligation on them to accept that role when the time comes. So if you haven't advised them, they're not aware of what you want them to do, it's very easy for them to just renounce, because it can be a lot of work. And then the other thing to keep in mind is that these documents, the power of signing them ends when the person who granted that power dies. So they're over at that point. So sometimes people call and they say, oh, mom's passed away, but you know, we don't want the estate to go to probate, so I'm using some power of attorney to take all the money out of the bank account for the bank knows that she's dead. That's fraud. So the power is over on the death. And then the other thing to know is that your attorney for property is entitled to compensation for the work that they've done unless the document does not allow that. So the rate is legislated unless it's changed by the document, and it's 3% roughly. So it's 3% of funds coming in, 3% of funds going out, and then 3/5 of 1% on the average annual value of the asset. So certainly, like the decisions that you make in these documents can have really serious impacts on your future care. And I think that a lot of the time people don't give it as much weight as it deserves. So if the people who are named, if they can't get along to make a decision, or there's a lot of things fighting, they're going to end up in court trying to sort it out. It's not always going to be possible to pursue these disagreements, right? But if there's no tension, it's kind of best to plan around them. Okay. And then the other thing I wanted to say about power of attorney is just like there is a couple of legal requirements that the document needs to meet in order to be valid. So it's going to be signed again in the presence of two witnesses. It can't be the person who's being appointed in the document or their spouse. That invalidates the document, so it's what we didn't have a power of attorney at all. They can't be a child of the person who's making the power of attorney, and they can't be less than 18 years old. You don't have to name the same person in both roles, but we talked about, making sure that those people can work together. And you can have, if you want to name more than one person at the same time, you can have a choice between whether you're going to require them to act jointly. So are they going to be required to make all decisions together, or are you going to allow them to act independently of one another, which is jointly and separately? So either one of those people can act. That's something to really think carefully about, because if you end up with a rogue actor, that person can be off doing things that the other people were not aware of until it's too late. So when I first started, I had this file where a woman had named her boyfriend and her brother, and her brother started jointly and severally on her property power of attorney. And by the time the brother figured out what was going on, the house was no longer in her name, been transferred to just her boyfriend. Some bank accounts have been moved around, and things, there was some funny business going on. So certainly, like, those kinds of things definitely can happen, and it's important to kind of think about how to best mitigate that if there's risks there. So I'm just going to go through as well what happens if you don't have a power of attorney. So there is some legislation that will step in for a very limited purpose. So we do have our Healthcare Consent Act. This is for treatment decisions only. It does have a hierarchy of someone who can step in and make a decision for an incapable person, or a person who's incapable of making that particular decision when there's no power of attorney for personal care. So this would be, it starts out, guardian of the person, we can talk about that, or a person named in a personal care power of attorney. Then sometimes you can go through a process to have someone appointed to make that decision by the consent and capacity board. That's a whole other thing I'm not really going to get into today. Then you get into relatives, right? Whether it's a spouse or a partner of an incapable person. If not, is there a child or a parent of the incapable person, or if they're a minor, sometimes when the children something like that, that's involved. And then we're looking at other relatives, so brother and sister, any other relative if possible. And then if not, sometimes the public guardian has people get involved in the and they are a government organization. Again, they're under the Ministry of the Attorney General, and their mandate is to protect incapable people in Ontario. So they're only going to step in very limited circumstances, if there's no one else available to make decisions, or if there's a disagreement between two people who are equally entitled to make the decision. Sometimes the PGT will act as the tiebreaker decision maker. They have a really high caseload. They are absolutely not going to get involved if they can otherwise help it. And they can be appointed, in a power of attorney or anything like that. So there is no equivalent legislative substitute decision maker for property. If you don't have a power of attorney for property, you become incapable. There's no one to step in and manage your assets on your behalf. Then we're looking at a guardianship application. So this is a court process where someone can be appointed to make decisions for someone else. They actually get appointed by the court to be the substitute decision maker. This is a really in-depth process. The person has to prove that the person that they're seeking guardianship over is no longer capable. There needs to be a capacity assessment done, typically by a qualified capacity assessor. When I first started out, we could sometimes get away with like a doctor's letter, 2 lines, this person is no longer capable of making decisions. Courts are now saying that's not really appropriate. It needs to really be a fulsome assessment of that person's ability. It is very, when you're taking away someone's independence, right, in the guardianship order. So the court has to find that the person is incapable, guardianship plan has to be proposed, that's put into place to manage that person's property, as well as sort of the basis of how personal care decisions are going to be made. And then the PGT is involved in that process, so the application goes through their office as well. They need to agree to it. And then once that person is appointed, after a period of time, they also have to provide an accounting to the public guardian and trustee to show that they were dealing appropriately with them. So a lot more process involved in that, much more expensive than doing a power of attorney for property, as well as, you may find in that guardianship application, person who ends up in a decision maker role is potentially not someone of the individual person who wanted, but nobody knows that because they didn't make their wishes known. Okay. I have a little bit of time left. I'm going to talk about estate taxation, which is one of my favorite topics, but hopefully not too boring. So we talked a little bit about the probate tax already. So there's I was thinking of it as two sort of types of taxation. There's your probate tax on assets that are passing through probate and your estate needs to be probated. And as I said, that really depends on what the assets are, how they're held, whether they're passing inside or outside of the estate. And I find as well, I got a lot of questions about how do I avoid this probate tax? And there are ways to do it, but oftentimes it's only worth doing if the assets are really, really high value. So there's specialized trust you can use for people who are over the age of 65. If you have assets held in a private corporation, there's something that you can do to avoid probate on those assets. But oftentimes the self-help remedies that people try to do are worse than just paying their probate tax in the first place. So the most common one people ask to do is to make a home when owned with an adult child. And so we've already talked a little bit about the issues with that there's a presumption that that results back into the estate anyway. If it's not done properly, you actually trigger a capital gain tax at the time that the child is added on title, and then when it's later sold, if it's not their principal residence, there's more capital gains tax to potentially pay. So usually the capital gain is going to be way worse than the 1.5% probate tax. So, that type of planning, to do it properly, it has to be done really carefully. There needs to be a trust agreement. Now, the trust reporting hit the mainstream news this year. People were really frustrated in the estate planning space and the accounting space with the CRA's position on fair trust, and so I think like some of that with the news. But potentially now the reporting for those types of trust is going to be really onerous. It might not be worth doing. But certainly if you think, you have an estate that maybe there's some ability to deal with some probate tax stuff there, you should talk to an estate planning lawyer, because self-help remedies often end up costing the estate more than what it would be in probate tax. Okay. And then sort of how an estate is taxed. So in Canada, we don't have like a death tax or a gift tax. It's really as though you have sold everything on the day that you died, and if you had done that, what would the tax implications have been in your tax return for that year? So in the year of death, your estate trustee will have to file a final T1 return, so that reports your income from January 1 to the date that you pass away. So depending on when you pass, it can be a lot or a little, and then depending on what the assets were. So if you had, a RIF, you have a cottage, and your primary residence, so you sold all of those. Your primary residence, you get the principal residence exemption. Hopefully, you will still have that in the future. Your cottage, there's maybe some capital gains that need to be reported and paid, and your rent is going to be as though cashed out with getting fully included in your income. So that can be a really potentially large taxation event, because suddenly it's bumping your income up probably way higher than it has been. So it's important to kind of understand that taxation and potentially plan for it. I mean, in most estates, those assets are being liquidated and the taxes paid off the top of the estate. Then the estate becomes its own taxpayer. So after that final terminal return, the estate has to file a trust return. So the CRA treats an estate like a trust. It files a T3 return, and any income that the estate is earning is taxed as well as taxed. For estates, you get a 3-year, typically a 3-year window where it can still pay tax at graduated rates, and then after that, trust and payment tax, top tax rate. So it's kind of it's an interesting taxation structure. There's no tax that's paid by the beneficiaries of the estate, so sometimes people worry, oh, once I receive my inheritance from an estate, am I gonna have to declare that in my income and pay tax on it? No, you don't have to worry about it. All of the taxes paid at the estate level, and it goes out to the beneficiaries. Typically, there's no tax to be paid unless there's something funny going on if they're a resident outside the country. That's an additional step to do there. So I always think, there's methods to reduce both probate tax and the estate tax, but typically that should not be the driver of an estate plan, right? You want to make sure that your other goals are met before you deal with the potential tax impacts. So I always tell my clients, let's think about, okay, you need a trust for a minor beneficiary. You need a trust for a spendthrift or spendthrift beneficiary. Let's make sure that those things work and that funds are coming to the estate to be actually administered properly. And then if we can figure out any way to reduce the probate tax or reduce the instant tax on death, that's kind of the cherry on top of the proper estate plan. So that is what I have prepared for about 45 or 50 minutes. You can ask some questions.
Laura, what obligations are on the executor as far as disclosure to the beneficiaries? If the beneficiaries want a copy of the will, things like that. Could you talk about that?
Yeah, that's a great question. So the question was, what are the obligations on the executor in communicating with and disclosing things to the beneficiaries? So if, the beneficiaries and anyone who has a financial interest in the estate is entitled to see a copy of the will. So there is a court application process that people can go through to ask the estate trustee to provide the testamentary document to the court. Usually it doesn't get that far because we have a lawyer on both sides, one writes to the other and says, we're going to bring this application and you have an obligation to disclose it. And then they can just send it over. As part of the probate application now, the will is also included in the probate application that gets served on all of the beneficiaries of the estate. If the beneficiary is only receiving a cash gift or a testament item, sometimes they will only be sent like the paragraph that specifically deals with them. But if they are receiving a share of like the overall estate, like a distribution of the residue or their percentage beneficiary, they're entitled to see the whole will. So usually for my estate trustee clients, early disclosure of the will is better, right? Because then you're not trying to hide anything or that sort of thing, right? If there's going to be an issue with the will, it's better to know it right away than to be like down the road and suddenly someone is trying to bring payment from disclosing property. As part of the probate application, what gets disclosed is just sort of the global value for probate tax purposes of the date of death value of any broken down to real estate in the estate and personal property. So it's pretty general, but the beneficiaries are entitled to ask the estate trustee for an accounting of the estate. So showing like what were the original assets of the estate, what brought into the estate, what had to be paid out, so what were the debts, that sort of thing for the estate, and then what's available for distribution. So typically, that information is usually not available until you're close to making an estate distribution. But sometimes beneficiaries get antsy and want to know that information ahead of time, and so then it just kind of depends on what are the circumstances of the estate and what is the estate trustee comfortable with providing to the beneficiaries at that point in time that it's being requested. I always think, the beneficiaries are going to see it all in black and white at the end of the day anyway, so it's better to have an open communication with flow with the estate, with the beneficiaries, because you don't want people questioning, right, what's going on. And oftentimes, you know, in the state, depending on the complexity of it, and then even the time of year that someone passed away, it can take a long time to resolve it, right? Like oftentimes, you might be at a year before you're able to distribute anything, depending on what the assets of the estate are. And sometimes beneficiaries just don't understand why it's taking so long, and it's not that there's anything being done inappropriately, it's just taking a while. So, you know, sometimes communication, disclosure can help sort of allay those concerns. Does that answer your question? Yes.
Does every will become a matter of public record ultimately?
Yeah, that's a great question too. So the question was if every will becomes a matter of public record. So if it needs to be probated, then yes, it is technically a public document, because anybody can go down to the courthouse and search the records of the court and get that bill. If it doesn't have to be probated, then there's really no public repository for it. So we don't have like a central will registry. There's some companies that have tried to kind of get that off the ground and doesn't have a lot of uptake. But unless it's probated, typically, no, it's not a public document. Yeah.
My mother is 99 years old, and she has made me and my two sisters all POAs of her estate and everything. We don't have an executor. And one of us to be the executor of that, of the estate, or do we have to, what do we do there?
Does she have a will?
She does, but it doesn't state that we're the executor, it's just POAs.
So there's no named executor in the will. So if she has a will with no named executor, then someone will have to apply to be appointed. And typically, yes, like, you know, depending on who the other people are in the family, it's just the two of you, like one of you can apply and the other just consents to the appointment. Yeah. Yes.
If, this is what I'm planning on doing. If I'm the last one, and twice passed away or whatever, can I sell everything I own, close out all my investments, and move into a nursing home? Am I gonna walk into a problem? And distribute all my money amongst my three kids?
Oh, like, so is this like a die with zero kind of?
Pardon me?
Is it a die with nothing kind of plan?
Oh, I'll leave enough money to take care of me, yeah?
Yeah, so I mean, honestly, you know, I've seen this sort of like there's a die with zero kind of growing movement, and it's not really a bad idea. If you have, you know, if you have enough to, you know, make sure your needs are covered, you're gifting during your lifetime, if you have liquidity to do that, there's a lot of benefits to that, right? Like you're not leaving it for someone else to deal with. You're able to see the benefits of your loved ones use that gift during your lifetime. So I mean, it just depends on the assets and, you know, making sure you have enough to live on. I have seen situations where that's happened and the kids say, oh, well, you know, if you run out of money, like we'll help you out, and then that does not happen. So there is, you know, there is like a little bit of risk associated with that, but you know, I always tell my clients, like, enjoy what you have, right? And like, gifting is part of that. So, yeah, I mean, your estate, depending on what your bank account is like, you might still need to probate, but there won't be that much there to pay tax on, so.
Because right now, maybe I got the wrong comment, but I'm not making any money at all in my investment. And I think like 90% of people are in the same boat, because they're not doing anything. So, you know, it's just a pain in the backside, and I just close it out and give it to the kids.
Yeah, and then of course, like you pay the taxes associated with closing it out of that,
Yeah.
I think it's not really, you're not to worry too much about. Yeah, I mean, I kind of like that. Yeah.
Like the kids do too.
Yeah, I would always recommend, you know, people still have like something in place, if they still have a will, they still have powers of attorney, right? Because sometimes we see estates where they're very low value, but even to deal with like the transfer of vehicle or closing a credit card or something, the company is saying, well, who is the executor, who is the estate trustee? And then it's the whole thing, okay, well, there's no assets really in this estate, but for whatever reason, somebody needs to be appointed to deal with it. And it's much easier, because sometimes if there is someone named in a will, they'll just accept the will, right? As proof of that estate trustee's ability to act. They might not, depending on the value of the asset, exist something. So still having those basic documents is really important. But yeah, anything fully reliable is great.
I have one more question. I bought an insurance policy in 1975. Company's been sold 4 times. I didn't even know who the freaking company was. So at last I tracked them down. My wife's life insurance was canceled when she was 65 years old. And so I read that thing over 100 times, and I can't see exactly, where it says that. And the guy that sold me the policy said 85 was cashable. And now this company's saying it's 100. So, and you call an insurance company, they won't even talk to you. It's not our policy, so we won't talk to you about that. You gotta call somebody else.
Yeah. So these types of insurance policy problems, because you're right, like there are companies now that are being bought by other companies. They used to be London Life, now they're Canada Life, then they're Great West Life, like who knows what's going on. So I have had clients have some success with dealing with, like most companies have like an ombuds person or a complaints process. So I had a similar, it was not the same, but it was an issue with the policy where the insurance company was saying that the deceased had named, at the time, their minor daughter on this policy in like 1996 or something. And the surviving spouse was saying, well, like, never would have done that. That makes no sense. Like, we were married. Why would he name our baby on this insurance policy? And they did the same thing, like they wouldn't talk to her, and she went through this complaint process and ended up getting it resolved favorably. So, most of them have buried in the details of their website the complaints process or the ombuds person to contact to find out those types of issues resolved.
Like, why would you agree to insure your wife for 50-some years and then they get up and cancel?
Yeah, yeah, I agree.
But I think I'm stuck. I don't think it's.
Yeah, I mean, I would try, one last ditch effort through their complaints process and just try and escalate it. See if we can get a satisfactory resolution. Any other questions?
One more.
Questions?
If there's a house, no cottage, with piece of real estate, and some RIPs and tax-free, and all the beneficiaries are in agreement with what's in the will, is there a need for the probate at all?
Yeah, so that is really going to depend on what third parties need to feel satisfied that the person named as the estate trustee is the correct person to deal with the assets. So for real estate, in particular, most of the time, in order to deal with a piece of real estate in the estate will need to be probated, because the land registry office wants to know that the person who is transferring that property out is the right person to be dealing with it. There is a very limited exception for real estate if the person owned it, but they bought it when it was in our paper registry system, and the government came along and converted it to land titles, like there is a probate exception there. But typically real estate is going to be a thing that triggers probate. Banks are, they have typically a policy where if the account is lower than a certain value, they may allow it to pass without probate if the estate trustee will sign a waiver and an indemnity that basically says if somebody later says, oh, bank, like that wasn't the final will, look, I have this later will, they're going to say, well, go deal with that estate trustee who told us this was the last will for it. But they're getting a little bit more sticky with that, and I've seen lately banks saying it's not even just the value of the asset of their location, it's the value of the estate globally, which really they shouldn't be concerned about, but they're getting stickier with probate requirements. just for, you know, fraud concerns and that sort of thing. Yes.
I have a question, and it's, regarding, husband and wife owning the house together. The one spouse, moves into long-term. So at which time does the permanent resident change the capital gains?
So if they own it with a right of survivorship.
Right.
And it is. Okay, so if one spouse leaves and that spouse passes away, and the surviving spouse is to own the home and sell the home.
Yeah, so one spouse is still in the home, the house is owned jointly,
Yeah,
the other one's living in a nursing home now past a year. And then 2 years down the line, that person buys or 3 years down.
yeah, so if it's the person who's living in long-term care who passes away, it flows by survivorship to the surviving partner. There's no, and I'm not like a tax specialist, but in my view, there shouldn't be a capital gain there because the person who ultimately disposes of the property, it was their principal residence for that whole period of time. But there is an issue sometimes with, if you leave a home and you're moving into long-term care, there's no intention to return to the home, it can cease to be that person's principal residence. From the deed that they left the home to the deed the home is sold in this area will sometimes make that decision. So I would say it depends on the,
Because I thought the permanent resident, that person in the long-term care home changes from the home address to the long-term care.
it does, but from a tax perspective, I think it would depend on who was the spouse who passed away last. And I think if it was the spouse in long-term care, then I think it would be from the deed that the spouse living in the home passed to the deed the home. Yeah, but I could be wrong on that one, so. Then Dr. can jump in if that's it.
Okay.
Because definitely like they'll be able to tell you for sure, but that would be my guess.
Can I ask you what you're finding as of today? How long it's taking to get probate in your area?
Yeah, that's a great question. So the length of time for probate, so in London right now, from the time you file to the time you get your certificate, is probably about 3 to 4 months. Then, you know, getting from date of death to being able to file kind of depends for me on how organized everyone was. So if the estate trustee very easily has a lot of information about the assets of the deceased and what the values were at date of death, then typically you can file for probate relatively quickly, depending also on how busy the lawyer's office is and how many files they have. But yeah, typically in London, it's like 3 to 4 months to get your certificate back. Some jurisdictions are much quicker and some are much slower. So the horror stories are always in Toronto, right? Like there we're sometimes seeing like 6 months to a year. Sometimes, you know, I've seen 18 months to get your certificate. And that's really tricky, right? Particularly if you have like high value real estate in Toronto. That can be a bit of a nightmare for sure.
Huron County has experienced that situation.
Oh, really?
Yeah.
Yeah, but it's taking a long time to get it. Yeah, so, and something that we're seeing too is that, you know, it used to be every courthouse had a estates registrar who would process these applications. Like I've had mine, I think like the ones I've submitted in Goderich are now like they get sent to Owen Sound.
Yes,
There's
they
like
are.
one person in Owen Sound who's
Yeah.
like trying to do all of these applications and like all of the other work is probably like 2 or 3 people. So definitely cutbacks come in.
So my experience was it sat in Goderich for 3 or 4 months. They decided they were way too busy
Yeah.
and overload. So then they sent it on to Owen Sound, which is in the same predicament.
Yeah, I've experienced that as well. Yeah, it's really. Yeah, and unfortunately, you don't really have a choice of where to file, right? You have to file in the county that the person was resident when they pass. Sometimes if they had, like if I had a client who had a principal residence in Toronto and a cottage I don't know, somewhere else. Maybe we get away with filing in that other jurisdiction, hoping that it'll be faster than, sending it into the black hole that is.
Yeah. Yeah. And there is a cottage involved on the shore of Lake Huron.
Yeah, it's empty. Yeah. Yes.
If you have a will and you do think it needs to be updated, if you're going to a different law firm, does it become a new will or is it an addendum or how do you do that?
Yeah, so did everyone hear the name? Okay, so the question was, if you have a will and then you're switching law firms, like how is that dealt with? You just need to make some changes. That really depends on the policy of the new lawyer, so, and how old the will is, right? So our policy typically is, like, I don't like to make changes to a will I didn't draft in the first place, because if there's issues with that will, I don't want to be taking them on as now my potential liability. So usually we would just start fresh with the plan and do a new will. Sometimes we'll do, in very limited circumstances, you can do what's called a codicil to a will, which is basically just an amendment that says, my will is still valid, but swap, paragraph A, where it says, my son is the executor, now I'm going to make my daughter the executor instead. Codicils are kind of a holdover from the time when you had to retype the will on a typewriter and nobody wanted to do that. We would just do a one-page codicil. Now, like for our clients, our wills are all done, they're Word documents, so if you're changing something, you might as well just sign them. So, makes it cleaner. I think most lawyers most of the lawyers that I know are probably not going to do a codicil to a will that they didn't previously draft, unless there's sort of some. Any other questions?
Can we talk about costs at all? Can you give us some general ideas?
Yeah, so there's a broad range. I mean, I'm in a big law firm, which carries big law firm costs. And, so our fees, we start at, I think it's $1,075 for an individual for the will and powers of attorney, it's $1,250 for a couple. That's our starting fee. So in our retainer agreement, it says that gets you your straightforward, everything to my spouse, equally among my kids, trust for minor kids, guardians for minor kids, powers of attorney, right? If we need to get into special planning, if we're doing a specialized trust or we're doing multiple wills for probate planning purposes, then the costs are going to go up. But certainly, there's lawyers working in smaller firms that are less expensive. Like I'm an estate specialist, so not every estate needs a specialist, right? So the fees things. I know now there's an online will companies, have been endorsed by the Law Society for access to justice reasons. So those can be an option as well. It's just making sure that it actually is doing what you think it's doing, right? So any complexity, I think it's better to have a lawyer actually giving advice on it.
When you need to amend a will or change one, you suggested starting a new one. Is the cost different between those two?
Yeah, that's a good question as well. So for us, and I can speak for every law firm that our practices, for returning client, we have a lower starting fee when they have a will with us that covers basically the cost of the initial plan and signing. And then the price kind of changes based on what the changes are. So if they're just popping in, they're going to change the executor. That price is going to be lower than if they are like adding a trust for a beneficiary with disabilities. But it is typically for returning clients, most firms have that policy starting, it's lower. Really, really good questions. Okay, thank you so much for having me.
Thank you so much for coming.
Thank you, Laura. That was great. Very, very helpful. And little token of our appreciation. Thank you as well. Yeah, I can stick around if you want to chat. Awesome. Okay, and for our at-home participants, we will be ending the recording now. Thank you.